Professor Whish, to what extent does a per se rule alleviate the burden of proof of the competition authority? Does it apply to every conduct or to hardcore only? Does the competition authority still have to show evidence of agreements in cartels? What about the need to show the effects or the harm to competition flowing from said agreements? Is there a de minimis criterion when it comes to restrictions by object?
Well, I must say that's a lot of questions, and I certainly can't answer them all in one sentence. Let's begin at the beginning. You're asking what is a per se rule, and I suppose you're also asking me, do we have per se rules in EU competition law? The first thing I'd like to say is that no, we don't have per se rules. If one looks at Article 101 of the treaty, which deals with anti-competitive agreements, as I'm sure you know, it's in three parts. The first part, Article 101.1, asks whether an agreement has the object or effect of restricting competition. But Article 101.3 is a terribly important provision because it says that if you have an agreement that restricts competition in the sense of Article 101.1, it can nevertheless be defended if it can be shown that it will lead to some economic efficiency. The third part of Article 101 says that if an agreement violates that provision, it's void and unenforceable. So if we go back to 101.1 and 101.3, it's true to say that Article 101.1 talks about agreements that have as their object or effect the restriction of competition. Now, some agreements are characterized by our law as restricting competition by object. If a particular kind of agreement restricts competition by object, then it follows that there is no need to demonstrate that that agreement has the effect of restricting competition because the law has already decided that that type of agreement has the effect of restricting competition, and so it is characterized as restricting competition by object. Now, in a sense, therefore, you could call that a per se rule. It's formalistic, it's legalistic, so we would say that a horizontal price fixing agreement has the object of restricting competition. But to say that that's a per se rule does not have the same meaning as it does under US law. Because under US law, if something violates Section 1 of the Sherman Act on a per se basis, that is the end of the matter. The parties to that agreement are acting illegally. But it's very important to understand that in the EU, even if the agreement has the object of restricting competition, so that in a sense it is per se in violation of Article 101.1, it is still possible for the parties to that agreement to argue under Article 101.3 that that restrictive agreement will lead to economic efficiencies. And so it is actually very misleading to suggest that we have a per se rule under Article 101 because we don't. Any kind of agreement can be defended under Article 101.3, but that's a matter of evidence. And our law is absolutely categorically clear that if the agreement violates 101.1, then the burden of proving that that agreement will lead to economic efficiency rests on the parties to the agreement to show that it satisfies Article 101.3. So that's a very long answer to the first part of your question, but what I'm saying is that actually we don't have per se rules in the EU. Now we could go on to another part of your question. You specifically ask what benefit is there to a competition authority either in having a per se rule or in EU language what benefit is there to the competition authority in the fact that some agreements are held to restrict competition by object? Well, I think the answer to that is really very clear, that if I'm the European Commission and there is an allegation that there is a price-fixing agreement or a market-sharing agreement for widgets, the mythical product of all competition law exam questions, it's very difficult for the Commission to prove the existence of the agreement, because these things are normally conducted in secret and evidence is kept to a minimum by the parties. They do not generate lots of written documents about the cartel that can be tracked down by the authority. So the competition authority has a very difficult job in proving the existence of an agreement. The benefit that they derive from the fact that price-fixing agreements are held to be restrictive of competition by object is that if they can prove the existence of the agreement, they do not then have to go on and prove that this price-fixing agreement will have an anti-competitive effect on the market, because the law has decided that price-fixing agreements have as their object the restriction of competition, and so there's no need to do effects analysis. So in that sense, there is a benefit to the competition authority of object analysis, because it foreshortens the inquiry. But then their inquiry is difficult enough already, because it's not easy to prove the existence of the agreement. But at least if they've proved the agreement, they don't then have to go on and prove that price fixing has an anti-competitive effect on competition, because the law says and knows that it does. But we still come back to my earlier point, that those parties to that agreement, if they want to, can try to argue that their agreement leads to economic efficiency in the sense of Article 1013, but then the burden of proof is upon them to adduce the evidence to demonstrate the efficiencies. And to be honest, if you've got a secret price-fixing agreement that's been in place for 15 years to fix prices and share markets, I think they have got an uphill struggle to demonstrate that that sort of conduct is economically efficient. Another thing you ask is whether there's any de minimis criterion when it comes to these kind of agreements, the sort of things that would be per se illegal in the United States, or that are held to be restrictive of competition by object in the European Union. Well, I can give a very simple answer to that because of a recent judgment of the Court of Justice called Expedia against the French Competition Authority, where the Court of Justice has held that any restriction of competition by object, by its very nature, has an appreciable effect on competition, and therefore there's no need to demonstrate the appreciability, because the law has determined that object restrictions have an appreciable effect on competition.
Okay. You usually talk about the practical aspects of restrictions by object, or even the PERSA rule in the US. Usually the benefits to the competition authorities. But overall, including in terms of uniformity of decisions and proportionality, which are particularly important for the private undertakings, what are the main pros and cons of a PERSA rule? What are the net gains or losses?
Well, of course, I have to repeat my point, which is that Article 101 does not contain a per se rule, because even an agreement that restricts competition by object can be justified under Article 1013 if the evidence is there to demonstrate the justification. So I think we have to rephrase your question to ask, what is the benefit of characterizing some agreements as being restrictive of competition by object for the purposes of Article 101(1)? Well, of course, that goes back to the point I made earlier, that from the European Commission's point of view, or in the EU system from the point of view of a national competition authority, because the national competition authorities of the 27 member states also can enforce Article 101. The benefit of object analysis from the authority's point of view is that if an agreement falls within what I always have called the object box, they do not then have to demonstrate that agreement has an anti-competitive effect in order to demonstrate an infringement of Article 101.1. And so, quite simply, that makes their job easier. Are there any other benefits of this characterization? Well, I think that another benefit is that there is some legal certainty that comes out of all of this, in that if I'm a legal advisor sitting down with my business client, I can say to them, if you enter into a horizontal price fixing agreement, market sharing agreement, if you indulge in bid rigging practices, if you indulge in a collective boycott of a particular undertaking in the marketplace, if you impose resale price maintenance on a distributor, I can tell the client that a competition authority or a court will consider those practices to be restrictive of competition by object, and that therefore they violate Article 101.1. So if you want to go ahead with this kind of conduct, and if you want to avoid infringing competition law, then you are going to have to bring me the evidence to show that we have got an efficiency argument that can be sustained under Article 101.3. And if you can't produce that evidence, I'm sorry, you have got problems. And it is likely that this agreement is going to be held to be illegal. So there's the benefit of the authority in terms of resources and what it has to prove, but I think there's also a net benefit to everyone involved in the system that this kind of characterization does give rise to legal certainty. It makes it easier to advise people as to what they can and cannot do.
Great.
I ought to just add, in fairness to people who do not like the characterization of agreements as restrictive of competition by object, that there are people who think that this is just simply too formalistic, too legalistic, and that in particular it somehow prevents proper economic analysis of the kind of conduct that we're talking about. That is a criticism that we often hear. Personally, I think it is a misplaced criticism, because, I repeat the point, even if an agreement violates 101.1, it is possible to try to defend it under 101.3. So if you had a horizontal price fixing agreement, which for some reason, because of the characteristics of the product or the nature of the market, is justifiable in economic terms, it is still possible as a matter of law, maybe difficult as a matter of practice, but it's possible as a matter of law to defend it under 101.3. And we always have to remember that 101.3 is there.
Do you believe per se rules or restrictions by object should apply to both corporations and individuals as well, even with no Article 101, paragraph 3, and even as a criminal offense?
Well, I have to repeat what I've said yet again. We don't have per se rules. We have a mini per se rule that says that some agreements restrict competition by object, but it is still possible to defend that agreement under 101.3. So EU law does not have a per se rule. US law does, but I'm not in a position to give you views on US law. I'm not an expert in it, but EU law does not have per se rules. Let me make a different point. And this goes to the question of whether we have criminal offences in Europe for which individuals can be punished. Now, it's quite a complicated story. The first point to make is that Article 101 applies only to agreements entered into by undertakings, and typically the undertaking is going to be the company, the partnership, the legal person. Article 101 does not apply to natural persons unless that natural person is him or herself carrying on economic activity. But an employee of an undertaking cannot be punished under Article 101. Only the undertaking will be punished under Article 101. So that's the first point to make. Second point to make is, therefore, that insofar as there can be criminal sanctions on individuals for infringing, well, for entering into cartel agreements, the illegality is not and cannot be the infringement of Article 101. There would have to be some national law imposing sanctions on individuals for certain specified practices. Now, various national laws of the member states do have criminal offences. We in the United Kingdom have one in section 188 of our Enterprise Act of 2002, and that law specifically says that what is illegal is for an individual dishonestly to enter into certain specified types of agreement, for example, price fixing, market sharing, or bid rigging. And if an individual commits that crime, he or she can go to prison for up to 5 years. But the crucial point to understand there is that individual is not going to prison because he or she infringed Article 101. He or she goes to prison because there has been a violation of the specific terms of Section 188 of the Enterprise Act. So when we're talking about criminalisation in the United Kingdom and whether an individual might go to prison, we're not talking about per se rules, rule of reason, object restrictions, effect restrictions. We are asking a narrow and specific question: has this individual infringed the specific terms of Section 188 of the Enterprise Act? That is a quite different offence from the undertaking infringing Article 101.
Thank you so much, Professor.